She certainly is alert. Today, I don't see any signs that she's detoxing. She told me that she was clean, and that was verified by Attorney McLaughlin when she came into the jail. So I think that is a good sign. Doesn't excuse the missing the drug court requirements, but the fact that she was not also using is certainly a good thing. The court is quite familiar with Caitlin's struggles. I think transitional living remains a good option for her, frankly, probably the best option. She remains willing and committed to doing that. It's just a matter of when that can happen.
Okay. Any response to that statement? Did you have any input from drug court treatment? I know Ms. Walsh is back there, but...
My understanding is that given some of her issues, it's a pretty complex situation. With regard to the TL, first of all, the state doesn't object coming back Tuesday for further. With regard to TL, that was being pursued while Ms. Berger was out, but she failed to follow through when the time calls. So that was being explored because of her lack of effort in kind of dispel that.
All right. Caitlin, how you feeling today?
Fine.
You know, yesterday when you came into court, you actually appeared much better than I was expecting you to appear. Hopefully that's improvement. The whole point of the last bail order that I issued was really to provide you case management and help in getting into TL and some support. And I'm going to detain you until next Tuesday when we'll take a look at this again. Drug court hasn't given up on you, and I want you to work with them when they come out, as long as your attorney's okay with it, to work towards TL, meet with Doug Gosway. I mean, this is what we were trying to do with you on the outside. Only now your attorney's going to be one of being your funding flag, your case manager. We were trying to help you verify dates, help you kind of get into that, because I think that's difficult for you for a number of reasons on the outside. So what I'm going to do is I'll order the bail be revoked. We're going to take a look at it again next Tuesday. Drug court's going to continue to meet and talk about what your future best plan is for you. In your record, you're not public enemy number one, Caitlin, and I still firmly believe in your case too much jail time is a bad thing for you early in your recovery, which is where you are. But we need you to show up, and at some point I got to make sure that there's a structure in place when you get out that doesn't put you at risk. Okay? So that's the order I'm going to issue, and we'll take a look at this again next Tuesday at 1 o'clock. Thank you.
Parties set up on state versus Dylan Amadon.
Okay. We're here in the case of State versus Dylan Emanon. Good morning, Mr. Emanon. We're here for a couple different offenses. I think the last time you were supposed to be in court, you weren't, and so a warrant was issued for your arrest. Here we are. So what are we doing? What's the state's position?
After some sort of cash bail, this is the second time Mr. Emanon failed to appear. When he was arrested, he gave the police a false name. Unfortunately, that false name also had a warrant, so then they realized it was Mr. Emanon, and so that brings him here today. He was arrested in Keene, and despite his excuse that he wasn't going to be local, which is why he said he missed the last. So given all that, Your Honor, the state has no faith in his ability to appear, so it asks for some form of cash bail. I left that blank up to the court, but I think that some cash bail at this point is necessary to ensure that. Thank you.
Good morning.
Mr. Emanon is indigent. He's told me earlier today that he has about $40 that was on him when he was arrested, so he has that, I believe, on his books at the jail. He has, in the last month or so, started working. He has 2 jobs, actually, one during the week and one on part-time on weekends. It's my understanding that this Friday is when he gets his first paycheck. But until that day, and if he's in, he's not going to be able to pick up that paycheck. But he would be able to post some cash on that day.
Where's he working?
He's working at S&S Concrete out of New Ipswich during the week. That's the more full-time job. And then on the weekends, he works with Francis Carpenter doing home cleanouts for banks. I spoke with him about court last week on the 4th. Your Honor might remember he did call the court that morning to say that he was in Connecticut. As part of his job, it's my understanding that they had him go to Connecticut. They paid for a hotel for him to stay in Connecticut, and that was sort of on a temporary basis last week when he couldn't make it in. He said he returned to Keene on Friday, I believe, and was picked up on Saturday. So he was in Connecticut at that time. Unfortunately, the paperwork and things, he doesn't have it with him because he's incarcerated at this time. But he does say he has information about, the hotel he was staying in Connecticut, and that it was for work purposes. So he does have those 2 couple of jobs. He also has just started getting visitations with his children again. He sees them once a month. They live about 3 hours away, and he has them for a weekend, essentially. But he also has child support requirements that he has through his sort of relationship with his children, of course, since they don't live with him. And so, obviously, maintaining work is very important to him. He hopes that he will have both of these jobs. He hasn't been incarcerated for too long at this point, and I don't think he's possible with understanding, so his hope would be to return to those 2 jobs.
Where's he living?
So it's my understanding that he has sort of 2 places. So one is the Cranhill Road address, sort of his paperwork here. That is the home of a friend's father. But they sort of have him on sort of a trial basis right now, so it's not full-time. When he's not able to live there, he's renting a room at 158 Church Street in Keene. That's the temporary piece. When he's not able to stay in that room, because that's what they're doing the trial basis.
I think I just signed a search warrant for 158 Church Street, just so you know.
I'm sorry?
I just signed a search warrant for 158 Church Street.
I was not aware. So when he's not able to live there, he lives at the Cranhill Road address in Swansea. And that is the home of a friend's father as well. So again, he has only about $40 in his jail account right now. He's not going to be able to have access to his paycheck unless he's out. And he doesn't, I asked him if he has anyone who could pick it up. Both of his parents passed away last year. He doesn't have a lot of supports in the community, or friends who could pick it up for him. To post that cash, he doesn't have access to anything at this point. And I think it's important that he maintain that work so he can maintain his relationship with his kids and continue to pay child support.
Restitution.
And his restitution.
Right. Mr. McClure, what's his record? I know that I'm familiar with the burglary case because it was one of those, there were a few of them connected to the Monadnock Highway burglary, if I recall correctly. His car and this one.
don't have it in front of me. I don't believe there was much on the record.
My record,
I certainly never
not
argued.
much, which is,
No, I certainly never argued dangerousness,
Yeah.
and I'm not an actor. It's just, he doesn't appear, and then when he's not here, and we talk to the attorneys, he hasn't talked to them either, so the cases are going nowhere.
And just one brief thing to add, so it's my understanding that, I believe Dylan has court in Keene District Court the week of September 27th. His boss gave him the whole week off, so that he could attend the court hearings in Keene. And because he has work off, he'd be able to, if we could schedule perhaps another dispo that week. He already has the week off, so the work conflict that he ran into on the 4th wouldn't happen.
Mr. Sweegarts, I'd like to schedule this for a dispositional conference on the 25th. Council, are you available on the 25th at 8:30?
Yes.
Mr. Wells?
I'm looking right at it. Sorry?
8:30? So Wednesday morning, the 25th?
Yeah, I'm scheduled to be in Jaffrey District Court that morning.
Okay. How about October 2nd, which is the next Wednesday?
That's fine. Scheduled to be next Thursday.
All right. All right, here's what we're going to do, Mr. Chairman. I'm setting bail at the amount of $1,000 cash. Bail is to convert a person with cognizance if you're admitted to House of Corrections EM program. Court requests review for EM on an expedited basis. Now, therefore, if you have a job and you have a residence that you say, I don't see anything in your record that's going to disqualify you from release on EM. Mainly, it's just because of your failures to appear, failures to keep in touch with your lawyer, and at some point, I'm afraid if I just let you out, we're going to be back here again. So you have 2 sets of felonies pending, and I'm just not confident you'll abide by the conditions that I set, unless EM is part of it. We'll have a dispositional conference on these charges at 8:30 on October 2nd, 2019. If you don't get out on EM, contact your lawyer, and we'll take it from there. Thank you.
Take care.
We're just gonna set up on Steve, Derek Cook.
Are you all set, Counsel?
We are, Your Honor.
Do you need some more time? I can.
No.
Okay, why don't you have a seat? We're here in the matter is State of New Hampshire versus Derek Cook. Mr. Cook, good morning. We're here because PPO Binks has filed a probation violation against you. You should not be surprised because she ordered you detained as a result of the violations that she's alleged. Counsel, have you had a chance to review the probation report with your client?
I have, Your Honor, we'd ask you to enter a plea of not true.
Shall do.
It was
And,
a small disagreement on that.
okay, what's the state's request for bail? Yes.
The state is requesting that the defendant be detained, but at the back of the form, the state has indicated that he may be eligible for electronic monitoring with the alcohol sensor, and that eligibility would be once he has an identified level of care and treatment set up for his release. So the intention is that the jail would complete an assessment and determine that level of care. I would note that his treatment provider, Darren Freeman, had been recommending that he do residential treatment. So that was the last kind of assessment that was done. And so I think there is a high chance that that will continue to be the recommendation, but I left it up to the jail to make that assessment. There is some initial indication that he may be eligible for EM with the alcohol sensor, so
Maybe ineligible?
eligible.
Or eligible?
So PPO Banks did have contact with Kathy Blasek. She actually Ms. Blasek reached out to the PPO. There is a district court bail order in place right now that has him detained but eligible for EM with the alcohol sensor. So she was able to give an initial response. She indicated that he is high risk, but that the alcohol sensor has reduced some of that risk. And certainly if there's a treatment plan in place, I think that will further reduce that risk. The defendant was sentenced in this case in January of 2019 for the sale conviction. He was serving out that sentence, eligible for work release. There was a violation of work release on February 25th of 2019, and then again on March 7th of 2019. That was detailed by Ms. Blasek. She indicated that the first violation, he left his work site early and did not report back to the jail per the contract he signed. He had actually been spotted at Applebee's by officers at the jail. He tested positive on a random UA back at the jail and admitted to having a tall boy at lunch, which would, they estimated to be the same as 3 beers. He admitted to drinking at lunch another time as well the previous day. And she went on to explain just where he stood with the jail and their requirements. So given that he very recently had been under programming, was having issues under that programming, and then now we have the new charges for operating after suspension, DUI. The state is concerned that without the treatment aspect as part of a precondition of EM eligibility, that he'll continue to have issues. There's also indication that PPO Banks received information that the defendant, when confronted, had admitted, confronted about empty containers in his vehicle, that he admitted to drinking and driving, and sometimes his children were in the vehicle. So the state is concerned not only about the defendant's activities, but also the impact that they have on his children. And so that's all the more reason that treatment should be set up prior to his release on electronic monitoring. And that is my understanding of our disagreement, is that the defense is going to be asking for just release on EM with the alcohol sensor, and that the defendant set up the treatment while he's in the community. However, given the issues as of late, the state, as I've already said, has concerns without that treatment in place of the community issues.
Commissioner Blaine?
Thank you, Your Honor. The standard is not whether the court or the state has concerns, it's whether there's clear and convincing evidence that there aren't any conditions that can assure a safe for the community. And I don't think we've met that here. Mr. Cook is not a risk of flight. There's not any indication that he was failing to report. He was reporting regularly as recommended. He's also seeing an alcohol counselor on Sundays. That is Darren Freeman. The reason we're not having a stronger bail argument here is because he had a bail hearing without counsel. He was at the jail. On the video, PPO Banks was there, and she was able to convince Judge Gleason to issue that bail order. It would take more time, frankly, for me to change that bail order than I think it would be likely otherwise for him to be getting out. So that's why we're asking that he be detained, somebody eligible for release on the alpha sensor in EM. The only reason that EM is necessary here is the alpha sensor. That is an additional level of treatment. It's going to indicate to the jail very quickly whether he has drank again, whether he's been drinking. And that's, frankly, the only issue in the VOP, really. The only issue, I think, that rises to the level of something that the court would typically see is because he's been struggling with alcohol abuse. Darren Friedman could recommend residential treatment. Frankly, the reason we're not asking for that now is I don't know what the recommendation is, and I don't think that the court should just automatically adopt that there was a recommendation for some level of treatment and say that the only way that Mr. Cook can be released is if he agrees to do that. His life right now, he is working, he is supporting 3 children. He might not be in a position where he could do residential treatment. And if he's not in a position where he thinks that is going to be helpful for him, it's not going to be beneficial for him to be ordered to do it and then for him to do it but lose his work, but not be committed to the program. So I think under these conditions, there is no risk of flight here. The only concern is alcohol. The alpha sensor automatically will tell the jail, and they will send the police out or the correctional officers out to get him if he tests positive. Typically, EM doesn't have that sort of automatic response. The alpha sensor goes off, my understanding is multiple times a day. So if he has any drink of alcohol, the jail will know about it, and they will quickly revoke him. That alone should be is a serious condition, and I think that's sufficient to ameliorate the court's concerns.
Well, the other issue, though, is he's on probation. I mean, and if probation tells him he has to follow the recommendations of his evaluator, he has to do that as a condition of bail.
Right, but
Not necessarily as a condition of release on EM, but as a condition of bail.
But I don't think I haven't seen anything that says Darren Friedman says you have to go to residential. It might be, I think you should do this. And then he can talk with Mr. Cook and they can come to an agreement, residential is just not going to work for you. Here's something else instead. And I think that makes more sense where Mr. Cook is engaged in the process and the court deferring to the jail and we don't know what the jail is going to come up with. And that's going to take a much longer period of time. Mr. Cook is currently working, he has several jobs that his clients that he is trying to do work for that he can't do work for right now.
The contractor, I see he's self-employed.
He's self-employed.
How's he getting around if he's got the DWI?
Well, it's an issue, but he does have transportation. He does have, what I can tell the court is, in this case, Mr. Cook had some serious family struggles that led to him relapsing before this incident. But the alcohol sensor is an immediate way for the jail to be notified and for him to be immediately brought back into custody if he's drinking. The other issue is I don't know how long it's going to take for that assessment to be completed. If he were released on the alcohol sensor, it might be done this week. The substance abuse treatment, given the fact that it's Wednesday, I don't know that that will happen in time. But because Mr. Cook is otherwise reporting and is otherwise seeing his substance abuse counselor, I think the court can be assured that it will occur in the future. It's not something where the court thinks if he doesn't do it at the jail, it won't happen.
gonna make this bail order the same as the circuit court. So you're detained, however, the bail may be converted to PR if you're admitted into the electronic monitoring program with the alcohol sensor. You have to comply with those rules. You have to live at an address approved by probation, can't travel outside of New Hampshire, can't possess a firearm, destructive device, dangerous weapon, or ammunition, no alcohol or use of any controlled drugs as defined by New Hampshire law, comply with the probation curfew, execute a waiver of extradition before your release, and you have to follow all the terms and conditions of probation, which is to include alcohol or substance misuse treatment. The defendant shall report to probation no later than 1 business day of release on EM. And you must meaningfully participate in continued treatment as recommended by Darren Friedman. So if he recommends residential, you got to do it as a condition of this bail, not a precondition to release on the alcohol sensor. They may think that the risk is too high if you don't have that treatment in place before they let you out, just so you know. But it's not a condition of bail. It's going to be up to the EM program. If you leave that program for any other reason other than successful completion, bail converts to detention. And those are the conditions. Do you have any questions at all?
Just one moment, Your Honor. No questions, Your Honor. Thank you, Your Honor.
Thank you.
State versus Daniel Tebow.
Well, Mr. Tito, what counsel purpose that is? They're all over here. I was never able to meet with the jail. I had a meeting scheduled and I canceled. So the whole EM thing is still unresolved. And I mentioned this to Mr. Parsons. Mr. McLaughlin was there. He didn't learn the case. Yesterday, so what are we going to do next? I did review that actually here. Is it fully agreed upon? I'll do whatever you guys want. I mean, I remember Mr. Tebow and I remember his case. Because I think, based on the representations at the last hearing, he's not eligible, because he was citizen. Pre-trust, yeah. What's the alternative? Do you want me to issue a waiver for him on it?
That's what we're discussing.
And then if he doesn't get out, then we have another hearing? Or I just issue a waiver?
It's my understanding that if you order,
Okay, so I'll try that.
That is my understanding as well at this stage.
Right. Right. Okay. You're doing very well. Mhm. Okay. Yeah, no, it's been on the bail. I remember his case quite well. You want to leave your forms, or?
yeah, so I want to word
What are the terms of the deal?
just give me 6 months, that would have to be certain.
Okay.
I'm not staying in the VOP, kill the VOP there, and then we 2 years in the VOP.
Okay. What's the alternative to the, can you order the right, well, let's try the EM, and if they say no, we'll know within a day or two, right? And then we can amend the sentence by paper. So I can't tell, Mr. Whitman, that was your word. I'll make it unclear. Is it on the
Yes.
forgery? It's on the forgery.
Yes.
The forgery. Yeah, they are. It's current on both. Okay. All right. Probation. No, you did. The probation's terminated.
On that one, we'll start again.
We'll start again on the forgery
Yes.
for 2 years. Okay. All right.
Thank you.
All right, thank you. All right, Tebow, how are you?
Good, how are you?
I'm doing okay. Okay, so it looks like you've reached an agreement with the state of New Hampshire and on the probation violation and the new forgery charge, which is the check for Walpole, savings bank of Walpole. That you'd be sentenced on both those to 6 months at the House of Corrections concurrent with each other, because they run at the same time. But you're immediately eligible to be placed on electronic monitoring, and you're going to report for service of that sentence Monday at what time? Council? Okay. And that probation on the old charge, which is the burglary, is going to be terminated, and you're placed on probation for 2 years on the new charge. And the probation term will start when he's on EM as well?
Yes.
Okay. And you're already on probation, so you know the drill with that, right?
Yes, sir.
Okay, any questions all about that sentence?
Not at all.
Right. I have this acknowledgement waiver of rights for the probation violation. I also have one for the new felony. Now, I know I've reviewed one of these with you before, for the
Yes.
felony. The rights on these forms are similar but not the same. You understand with respect to the probation violation, you're waiving your right to a hearing in front of me. You understand that?
Yes, sir.
And you're waiving your right not to be found in violation of the rules unless the state convinces me it's more likely than not that you violated them. Got it?
Yes, sir.
Any questions about that?
No, sir.
On the felony, you're waiving your right to a speedy and public trial by a jury of your peers, right? The jury would determine whether or not you're guilty or not guilty, right?
Yes, sir.
And you're also waiving your right not to be convicted of that forgery unless the state proves your guilt beyond a reasonable doubt. They'd have to prove beyond a reasonable doubt that you knowingly uttered it or wrote a check with the purpose to defraud the savings bank of Walpole. You understand that?
Yes, sir.
Sign someone else's name, right?
Yes.
Okay, any questions all about what the state would have to prove on that offense?
No, sir.
Okay, with respect to both of these, you're waiving your right to have your lawyer defend you, cross-examine any witnesses, call any witnesses that might be helpful. You understand?
Yes, sir.
And waiving your right to have me order into court evidence and witnesses that might be favorable to you, right?
Yes, sir.
Any questions at all about any of the other rights in these forms that I haven't specifically reviewed with you?
No, sir.
Do you understand them all?
Yes, sir.
Other than the plea agreement, did anyone make any threats or promises in order to get you to plead guilty here today?
No, sir.
Are you doing so freely and voluntarily?
Yes, sir.
Counsel, do you know of any reason why I can't accept this plea? Mr. Tebow, did you take any drugs or alcohol before coming to court that would affect your ability to understand these rights or the consequences of your plea?
No, sir.
I'll find your waiver of rights on both the probation violation and the new forgery charge is knowing intelligently and voluntarily made. If you'll stand, I'll take your plea to the forgery, which is a Class B felony. To that offense, Mr. Tebow, how do you plead? You guilty or not guilty?
Guilty, sir.
Okay, for the related probation violation charge, which alleges that you violated probation by committing the forgery, how do you plead to those allegations? Are those allegations true or not true?
True, sir.
finding it true and a finding it guilty or entered upon both your pleas are free of any coercion and are the result of a knowing, intelligent, voluntary decision on your part. Would you have a seat? Say what should be heard in sentence.
Just briefly, Your Honor, Mr. Tebow is a difficult case because he was going to court on, this will be his third felony now, but, and I don't say this part to insult Mr. Tebow, but they've all been stupid felonies, quite frankly, and impulsive. He ended up with an arson for just, trying to rob a coin-operated washing machine. And then there's a burglary, where essentially he just enters to a tenant's house at his parents' house and takes something. So they're all felonies, but they're all extremely low-level felonies. The court, and I've never saw a lot of time on Mr. Tebow, and I don't believe it's appropriate. I do thank the court that you're willing to order the EM, because I think the strict monitoring is more helpful in Mr. Tebow's case. So I ask the court to impose that and ask the rationale behind the state's recommendation. Thank you.
Attorney Parsons.
Thank you, Your Honor. I think the court's pretty familiar with Mr. Tebow's history. I won't belabor it. I would just like the court to know that he has been doing well. I think there's progress for Dan. This charge is a year old at this point. He's remained on probation. There was a driving charge, but otherwise he hasn't had other violations. He has been pretty consistently working. Not too long ago, he was working 2 jobs, and now he has a new full-time job, which pays better, and I think will be better for him. And also we had an evaluation with Dr. Hart, who thought he should be assessed for medication. It's taken a long time to get a psychiatric medication assessment done, but that is scheduled with MFS now, so we're optimistic that will be helpful as well.
No, I know at some point there was an issue about children and that whole thing, but does he have any obligations?
He does.
For family?
He fairly recently learned that there's a 3-year-old who is his biological child, and he is invested in that. He's involved with his child, and he's paying child support. And he also learned that he and his girlfriend have a baby on the way. So that's a motivator for him. It's important to him to be a good and responsible father. And they are residing together. I would note that Dr. Mart thought it could be helpful for him to receive services from the local developmental disabilities support system. We had him assessed by the Monarch Developmental Services. Unfortunately, they declined to provide services. Their conclusion was that his issues are primarily mental health rather than developmental. So he's working with MFS.
That's why they wanted a medical review?
Yes.
Yeah. Okay. All right, well, he's on probation, so probation can steer him in that direction. What I've sentenced him to is 6 months current term starting Monday, 9/16 and 2019 at 7 p.m. On both sentences, I've stated that the defendant shall be placed on EM on an expedited basis so that he may remain employed and take care of family obligations. That language is appear on both of them. Hopefully that's clear enough. I haven't put it on the recommendation section. I put it as a separate sentencing order. Okay?
Your Honor, I did omit to put the restitution amount in there. I apologize
For
for
the
that.
forgery? What was it?
It's $469.22.
439.
$439.22. I'm sorry about that.
That's okay.
$439
And 22 cents to the savings bank wall.
for restitution.
And through the Department of Corrections as well.
And I would just ask if the availability of 7-day sanctions for minor probation violations is well.
Yep, that's included in the sentencing form.
Thank you.
Okay, so restitution in the amount of $439.22 to Savings Bank of Walpole through the Department of Corrections.
Thank you.
Okay? All right, we'll see what happens. Thank you. So, wait, before we begin, before we adjourn, sorry, Mr. Tebow, I'm sure your lawyers explained to you, you have a delayed report date, okay? If you, which means you have to show up Monday night at 7 o'clock at the House of Corrections, okay? You're not gonna get out on the Monday night.
Right.
I can tell you that right now. It may not be on Tuesday. It might be Wednesday, because they have to process you and, you have to sign a bunch of paperwork and stuff like that.
Yes, sir.
I've done the best I can to get you out on an expedited basis. One thing that'll make this impossible is if you show up and they drug test you and you test positive for anything that you don't have a script for. Okay? So they're gonna do an interview with you and they'll ask you about your drug use. If you smoked marijuana 2 weeks ago, you gotta tell them. But if you lie to them, they're not gonna let you out on EM even with this language. Okay? They expect you to be honest about that type of stuff. And so they'll know if you go out and you drink or do drugs or whatever in the few days before you have to report, which is, the rest of this week. They'll just say, sorry, even if the judge put it on there, you're not wearing one of our bracelets, you're staying here. And they'll send us a note and let me know if that happens, okay? So you can't do it. Also, if you fail to show up, you can be charged with escape. Because as of 7 p.m. Monday night, you are in official custody of the state of New Hampshire. So if you do not show up, that means you're an escapee, okay? Warrant will be issued for your arrest and you can be charged with escape. Then you're never eligible for EM again for the rest of your life. You understand?
Yes, sir.
Okay. Like the prosecutor said, most of your felonies so far have been impulsive, not the result of mature decision-making is the way I look at it. But you're running out of slaps on the wrist. Okay, this is 6 months, and if you mess up again, it's going to be worse and worse and worse. Do you understand?
Yes, sir.
Okay, any questions about that?
No, sir.
All right, thank you. That's the report. Good luck.
Thank you.
Yeah, has Ms. Moore shown up?
No, Your Honor.
All right, state requesting warrant.
Please, Your Honor.
Okay, submit your request or see if Pam can write one up and we'll do it, sorry. Okay, thank you. Thank you.
State versus William Prescott.
Okay, have a seat, William. What are we doing with Mr. Prescott? We have theft charge of the TV, we have the sale for, who was out in, I think it was Winchester, if I recall, for Berrybrook Road. And then the violation of probation that's related to both of them. And absconding. Lots happened since then. What are we doing?
You have negotiated extension.
Okay. All right, on approach. Thank you. How you feeling today, Mr. Prescott?
Great.
Okay.
How are you?
Doing well. Okay. All right. Mr. Prescott, looks like you're going to be pleading guilty to pending drug felony, sale of fentanyl, the theft of the TV, which is a Class B felony because of your priors, and then the related probation violation. And it looks like the agreement that you have is that on the probation violation, you'd be sentenced to 9 months with all but 30 days of the sentences suspended for the rest of your probationary period. Okay, so for as long as you're on probation, that 8 months or so is suspended over your head. You're given pretrial confinement credit of 30 days because you've already done that time before I let you out on bail. So that is that sentence is satisfied with respect to that portion of the stay committed portion. Probation is stayed from December 13, 2018 until July 8, 2019. Special condition of your probation on this docket number is that you successfully complete the behavioral health court program without interruption. Okay, you have to start, finish it all the way through. I know you're already in. All of the priorities remain in effect, and any evidence collected can be returned and destroyed. Now that's on the VOP. On the theft charge and the state prison charges, these are different. Now, I'll start with the sale charge, sorry. The sentence on that charge is 1 to 3 years at the state prison, all suspended for 5 years from today. Now, this sentence is consecutive to the suspended probationary term on the one that you're on probation for. You understand that?
Yes, sir.
And you're placed on probation for 2 years on this charge. And this probationary term is consecutive to the one that you're on probation for now. You understand that?
Yes, sir.
So you're adding a 2 more year probationary term on. There's a suspended fine, $500 plus the $120 penalty assessment. It's all suspended for 2 years. You do have to make restitution to Keene PD for the $200 buy money. Okay? You have to pay that through the Department of Corrections. On this sentence and the next one, if you're ever incarcerated at the state prison, you're eligible for earned time, and you have to complete any counseling, treatment, and educational programs. You also have to remain in good behavior in both these sentences, and all evidence and contraband can be returned or destroyed based on these 2 sentences. That's with respect to the drug charge. Now, with respect to the theft charge, it's a bit different. It's 1.5 to 3 years at the state prison, all suspended for 10 years. Okay, now this sentence is consecutive to the sale. It's also consecutive to the VOP. There's a typo on this one though. It should be 213-2016 CR, not 2014.
I was going to see off the last charge that you never apologized for.
Okay, see. So that basically you have hanging over your head 8 months plus 1 to 3 plus 1.5 to 3. Okay, so that's, you do the 8 months first, and then you'd be shipped off to the probation. That's if all this is imposed. Then you'd be shipped off to the state prison for at least a year, followed by a 1.5 years. So that's 2.5 to 6 years kind of hanging over your head. Okay, they calculate the 6 years a bit differently, but that's what you have hanging over your head. You understand?
Yes, sir.
Any questions about that?
No.
Okay, also on the theft charge, you got to pay restitution of $498 to Walmart through the Department of Corrections. That's for the TV, right?
Yes, sir.
Okay, same provision of earned time credit applies to this, as does the return of destruction of evidence and the requirement of good behaviors, always a condition of suspended sentences. Okay, any questions?
No.
Okay.
Excuse me, Robert,
Yes.
on the drug charge, under 12C, I had added, should the sentence be imposed, well, I'm going to be on probation, so I asked that charge, that language, should the sentence be imposed, be deleted, it's not.
Okay, all right, that's fine. So a condition of that sentence is that you have to complete any counseling, educational treatment program as directed by your probation officer. Okay, you understand?
Yes, sir.
Obviously, you violate probation on this, you could be looking at more than 1 to 3 years. You could be looking up to the statutory max in this case, which is 3.5 to 7 years, based on my reading of the indictment. You understand?
Yes, sir.
Okay. You waived sentence review for those 2 state prison sentences. I see that. And I have this acknowledgement waiver of rights for the probation violation and felony. Now, William, I reviewed both of these types of forms with you before, okay? And you just saw me review them with the gentleman before you, Mr. Tebow, so it's the same deal, same rights. Do you understand?
Yes, sir.
You understand you don't have to plead true to the probation violation or guilty to the 2 felonies, but by doing so, you're waiving all the rights on these forms. You understand that?
Yes, sir.
It looks like you filed both of these forms and signed them on the 11th, and that you completed some college, which I know, okay? You understand with respect to the probation violation, you're waiving your right to a hearing in front of me and waiving your right not to be found in violation of the rules unless the state convinces me it's more likely than not that you violate them, right?
Yes, sir.
And with respect to the felonies, you're waiving your right to a speedy and public trial by a jury of your peers, and waiving your right not to be convicted of the sale and the theft of the TV unless the state proves your guilt beyond a reasonable doubt. You understand that?
Yes, sir.
You know, I was just checking the drug penalty section,
Okay.
and the section that talks about
Oh, it's 1 gram or more.
1 gram or more.
Is it 7 after 15?
No, it says in violation of any of the following, a person may be sentenced to a maximum term of not more than 20 years and fine of not more than $300,000 for both.
So it's a 10 to 20? All right. It's a lot of time, man. You understand?
I do.
That's the max for that if you violate probation. Okay. Thank you, Counselor. With respect to both of these offenses, with respect to the 2 felonies, you're waiving your right not to be convicted unless the state proves you conducted the sale as alleged on the date and time of the indictment, and that you purposely obtained property of Walmart, which is the TV. You have 2 priors. That's what the state would have to prove on those 2 offenses. You understand that?
Yes, sir.
They have to prove that beyond a reasonable doubt. With respect to both of these proceedings, you're waiving your right to have Attorney Frankel defend you, cross-examine any witnesses, call any witnesses, and put up your defense. You understand?
Yes,
And you're waiving your right to have me order into court evidence and witnesses that might be favorable to you, right?
Yes, sir.
Any questions at all about any of the other rights in these forms I haven't specifically reviewed with you?
No, sir.
Other than the plea agreement, anyone make any threats or promises in order to get you to plead guilty here today?
No, sir.
Are you doing so freely and voluntarily?
Yes, sir.
Counsel, you know of any reason why I can't accept this plea?
No, Your Honor.
William, did you take any drugs or alcohol that would affect your ability to understand these rights or the consequences of your plea?
No, sir.
All right, I'll find your waiver of rights as knowing, intelligently, and voluntarily entered. I'm familiar with both of these offenses because we had a couple bail hearings on his case. So there's a sufficient factual basis to substantiate your pleas to both and the DOP. Your waiver is knowing, intelligent, and voluntary, so if you stand, I'll take your pleas. To the indictment for the quantity for the sale of fentanyl. William, how do you plead? Are you guilty or not guilty of that offense?
Guilty.
With respect to the theft of the television from Walmart, how do you plead? Are you guilty or not guilty of that felony?
Guilty.
And with respect to the related probation violation, actually, I believe there are 2.
There are 2, Your Honor.
There are 2.
They're going to be true pleas to all, except on the December 13th, 2018, there's a Rule 7 for driving after suspension. We're going to ask to enter no contest on that. That's still pending.
Still pending?
It is.
How is that still pending? Sorry, this is a rhetorical question. You don't really-
This district court moves slowly.
Okay. Pleas are true or entered except for that Rule 7 violation. It's a no plea. But findings are true or entered on both of those. I'll find findings are guilty or entered on the 2 felonies. I'll find all your pleas are free of any coercion as a result of a knowing, intelligent, voluntary decision on your part. Once you receive. Statement should be heard on sentencing.
No, Your Honor, thank you.
Does probation know about this?
Yes, they do. In fact, we discussed the offer before it was made, and since we had an agreement and it's reporting day, PPO Conifer asked if he needs to attend, and I indicated I could do it without him since.
Okay. All right. Ms. Gallagher, you've been here all morning. What should I know about how Mr. Prescott's been doing?
So I'm covering for Ashley, who's his primary case manager, but he's doing well. He's attending all urine screens, back in July 30th. He had one slip up and then he's been doing well. He's
What was the slip up
orthopedic
for? What drug did he test positive for?
On July 30th, it was fentanyl.
Okay.
So he's still, and he is receiving medication-assisted treatment through Phoenix House and also individual therapy. He's working, he's actually also going to school for an apprenticeship to be certified as an electrician.
Good.
Looks like he's going to AA meetings pretty much daily, and he's doing well.
Attorney Franklin, anything I should know?
Unless you have additional questions, I think Ms. Gallagher summed it up right, it's headed in the right direction, the sentence keeps ahead of it.
All right, William, you want to say anything? You want to talk me out of it? No? Okay. Are you in a real program for electrician apprenticeship?
Yeah.
Okay. Oh, good for you. That's how I paid my way through college, working as an electrician.
Really?
My dad's a master electrician, and he's still working at 78 years old, pulling wires. All right, those sentences are imposed, William. I should say for the record, I've been referring to you as William because you're a drug court graduate. I hope you abide by the conditions, and if you do, hopefully you won't have to see me again, okay? You have any questions about this? All right, good luck to you.
Thank you. Thank you.